Hello everyone, welcome to Apti Plus Academy for Civil Services. I hope all of you are doing well. This is a video session on monthly policy review, which is actually released by the PRS Legislative Research, and I'll be discussing MPR for the month of February. Through this discussion, I'll be giving you the details about the important bills that was passed by the Parliament, some of the important news related to the legislative process, and important constitutional development that was there for the month of February. So we'll see and understand important news for entire month of the February and give you the important point that will help you in the civil services examination. So this session is going to help at the both stages of the examination, either it is prelims and main, and even have a substantial contributions to the personality development. So let's get started with each news one by one, starting with the first one, that is the electoral bond scheme. This was long debated and it was there for the entire month. So you need to understand what exactly is the electoral bond and what was the finding that was given by the Honorable Supreme Court and how it has come to a conclusion where the electoral bond, or you can say EBs, was actually categorized as unconstitutional. So a total of 5 bench of the Honorable Supreme Court has found it after a thorough investigations and deep conclusions that the electoral bond are unconstitutional. Now this unconstitutionality given by a mandate given by the Honorable Supreme Court make it inactive. Now there will be no more issuing of the electoral bond. Now the scheme was actually introduced by the Finance Act 2017 के थ्रू इसे इंट्रोड्यूस की गई थी और 2017-18 से ही ये इलेक्ट्रल बॉन्ड्स जो है वो फंक्शन में आएंगे. Now, before I come to the other details, you need to understand that which actually the political parties have received how much of the total corpus that was there. So this is the total value of the electoral bond that was sold between 2017-18 to 21-22. So the maximum part goes to the ruling party, that is BJP, followed by the other party like Congress, TMC, BJD, DMK, NCP, AAAP, and JDU. So these are the details, precise information that I wanted to share with you. Although you not need to have a precise detail on the data as such, but आपके general understanding के लिए चीजें important. Now, what is electoral bond? I think most of you must be aware for time being that what actually is the electoral bond, but I give you the precise definition. So it's an instrument that can be used to make the donations to the political parties. Suppose A as an individual who is favoring any of the party, he can be an individual, he can be a company, he can be a party. So he can make a donations to X party, but this is the only method where the donations can be made without having any disclosure. Now, there's certain ambiguity which still exists with the electoral bond that was categorically highlighted by the Honorable Supreme Court. We'll see the observation later on. Just try to understand what exactly is electoral bond. So any citizen of India or a company is eligible to buy the electoral bond, right? And these do not carry the name of purchaser. जो भी purchaser होंगे उनकी किसी भी तरह की disclosement नहीं की जाती है electoral bond में. Now the political parties are also not required. Now these political party who is actually getting the part of electoral bond, they also do not need to require the disclosure of the part of the bond received. This was actually the changes that was made to the Finance Act 2017, where basically they amend the Companies Act to remove the ceiling of the total amount that can be contributed to a political party. There's no ceiling, the number, the amount that can be there, but there's certain denomination which is actually used for the electoral bonds. Now, it also removed the companies to disclose the name of the parties which contribution has been made. Now, this was the all vagueness and ambiguity which actually exists with the electoral bond before the Supreme Court actually come up with the conclusion, or even they have awarded that this is an unconstitutional in nature. Now, what was the examination that was made by the Honorable Supreme Court? It was basically on the two front. First, the Supreme Court has said whether the unlimited corpus funding to the political parties was violated for free and fair election, because in a country where certain part of the restrictions has been there, if you look at the MLA and MP elections, there is something amount of corpus that has been already there by the RP, the Representation of People Act 50 and 51, right? So there's certain restrictions which has to be adhered by the political parties, which was not actually there, right? So whether the right of the political parties to keep voluntary contribution undisclosed supersedes the voters' right to information to know the same. So these were the two important front which was actually examined by the Supreme Court, where five judge bench has come up with a detailed conclusion and observation to this. So, what was the observation that was made by the Honorable Supreme Court? The court held that the EB, that is the electoral bonds, violate the right to information. जो right to information act है, which is actually under the part of Article 19 of the fundamental right, जो कि right to freedom of speech and expression है. Now this is the fundamental right 19. उसके अंदर आरटीआई को लाई गई थी, एक important tool और power देती है citizen को किसी भी गवर्नमेंट डिपार्टमेंट या ऐसे ऑर्गेनाइजेशन से इंफॉर्मेशन लेने के लिए. It also held that the unlimited access to corporate contributions to the political parties violate the right to 14. What is right? The Article 14. Article 14 categorically speak about the right to equality. How it is violating the right to equality? I've shown you a picture where BJP was actually getting the highest share. Even there was a half, more than like one third, and even to less that was to the Congress and other part. सो इस तरह से कहीं ना कहीं जो एक पार्टीज है उनके में जो राइट टू इक्वालिटी है उसमें डिस्प्रपोर्शनेट वायलेशंस देखी गई है. Now, the part of the Supreme Court has also directed that the state bank to stop issuing of the electoral bond. This was something which was in directions given to the State Bank of India. Now, SBI has also directed to submit the details of the political parties that have made contributions since April 12, 2019. तो जो 2019 के बाद से जितनी भी contributions की गई है उसके disclosement करनी है State Bank of India. SBI must also disclose the electoral bond that is crashed with the political parties with the Election Commission of India's website. और जितनी भी bonds जो इनकैश की गई हैं वो सारी डिटेल्स उनको इलेक्शन कमीशन को देनी है. And the ECI, that is the Election Commission of India, will actually make the public, this will be made public on their official website. Now, the development that took place, the recent development even for today, the Supreme Court has categorically said even a contempt was filed before the Honorable Supreme Court that SBI has said that they will be requiring another 3 months to provide the other details. But the Supreme Court today itself has said that they have to provide it by tomorrow to the Election Commission of India and have to publish the details of everything by 15th of March on their website. So these are the latest development as of now. When I'm recording this lecture, you must be aware of this updated information as well. Now moving ahead with the other important news, that is the bill prohibiting the use of unfair means in the public examination. Now this is again very important as an aspirant for civil services examination or as an aspirant for other competitive examination. This bill is pretty relevant and this was a need of the hour. So you need to know the important provisions of the bills and the penal provisions that is also intact with it. So the Public Examination Prevention of Unfair Means 2024 was actually passed by the Parliament और इस बिल के थ्रू जो अनफेयर मीन्स ऑफ पब्लिक एग्जामिनेशंस में जिस तरह से की जाती है उसको बहुत हद तक रोकने में मदद मिलेगी. What is public examination? This is a general competitions which is conducted by the authorities specified for particularly, and this can be there by the state government or either by the central government. इसमें एक एग्जामिनेशंस की बात करें जो ऑर्गेनाइजेशन इन्वॉल्व होती है, फर्स्ट एंड फॉरमोस्ट द एपिक्स बॉडी दैट इज द यूनियन पब्लिक सर्विस कमीशंस, देन वी हैव एसएससी दैट इज स्टाफ सिलेक्शन कमीशंस, राइट. So then we have RRB, that is the Railway Recruitment Board, National Testing Agencies IPPS जो कि मोस्टली बैंकिंग सर्विसेज के लिए एग्जाम कंडक्ट कराती हैं, एंड डिफरेंट central government and their attached offices for the recruitment purposes. So this all will be included under the Public Examination Prevention of Unfair Mean bill that is there for 2024. Now this is a particular image that will give you a brief idea that where the in particular state of the country, how many examination was conducted, basically what was the leakage, I mean the part of the total fraud or the part of the examination that was conducted and how it has actually ultimately led to the leak. So for JNK you can see these are the data. Even you can take a screenshot for your references. This will not be that relevant from the examination point of view, but for your general standing you can have a better picture. Now moving ahead, what are the key features of this bill? The bill defines several offences in the public examination. I've told you what is public examination. If you are asked to define the public examination, do write it because this will have a clarity on part of your understanding. Now, it prohibits the conclusions on conspiracy to facilitate the indulgence of any kind of unfair means. So, this unfair means had a wide coverage, and even the authority has to decide whether an individual was indulged or not. Now, specific unfair means की अगर बात करें, unauthorized access or leakage to a specific questions paper or answer key is considered to be unfair means. उसके अलावा assisting candidate during the public examination किसी भी तरह की हेल्प अगर की जा रही है तो अनफेयर मीन मानी जाएगी. Tampering with the computer network or resources, because many examination that is conducted online has to be ensured that a proper security check is there. Tampering with the document for shortlisting or finalizing the merit list or rank, and conducting fake examination, issuing fake admit card, or even offer letter for a cheat or a monetary gain will be considered as an unfair mean, and this all will be under this particular bill. Now, कुछ other prohibitions की अगर बात करें, disclosing the exam related confidential information before the examination is also prohibited. Unauthorizing people from entering the examination center to create disruptions, and avoid offences which will have a punishable offense with imprisonment between 5 years, 3 years to 5 years. This is the basic, the part of the penal provision which is there, and fine up to 10 lakh rupees, which has been further increased, and even the government is looking forward to increases further to the crore rupees. Now, in case of the part of the violation which is there, this is something which was there for the earlier one. This is the earlier one. Now, the current one, the government has come up with the penal provision with 1 crore rupees and further barred from conducting any kind of public examination for 4 years. सर्विस प्रोवाइडर को डिफाइन की गई है इस पर्टिकुलर बिल में. सर्विस प्रोवाइडर वो होंगे एन ऑर्गेनाइजेशन दैट प्रोवाइड कंप्यूटर पार्ट ऑफ द रिसोर्सेज विच इज देयर, any other support for the public examination, or even to the other authority which is concerned with the conducting of the examination. Now, failure to report such incident will be also counted as offense. अगर किसी इंसिडेंट को रिपोर्ट की गई है उस पर्टिकुलर सेंटर में और वो रिपोर्ट नहीं की जाती है पुलिस के साथ या लॉ इन्फोर्समेंट एजेंसीज के साथ, then this will be counted as offense. In case of service provider, the examination authority must report it to the police, right? Now, moving ahead, draft greenwashing guideline. I think most of you must be aware with the term greenwashing. Now, in this context, this was actually issued by the Central Consumer Protection Authority. They have issued the draft guideline for preventions and regulation of the greenwashing under the Consumer Protection Act of the 2019. Now, why it is important? Because of fraudulent activities ongoing with regards to this part. So, greenwashing refer to the use of misleading word or any kind of advertisement which actually is not existing, creating a vagueness and illusion, and even positive environment aspect is there with a downplaying and concealing the harmful attribute. So this is malafide in intention which actually does not exist and create a part of psychophobia kind of thing which is there with the part of greenwashing. Now, there are some attributes to the greenwashing. I mean, if you look at the 6 sins of the greenwashing, you can even write this in mains examination if it is asked that what are the 6 sins. First is the vagueness. जहाँ पे किसी भी तरह से vagueness, I think the term is pretty common for you. Lesser evils, irrelevance that is existing, hidden trade-off is intact with the part of greenwashing. No proof. If you are making a substantial proof or even that has to be documented with an evidence, there is no proof to that. And flipping, which means that making environment claims that are simply false. So these are the 6 main sin of the greenwashing. Now, कुछ ग्रीन वॉशिंग की अगर बात करें जहाँ पे ये प्रोहिबिट की गई है, द गाइडलाइन प्रोहिबिट engagement in the greenwashing or advertisement for the specifically part of the communications. It will apply to the service provider, जो भी individual service providers हो किसी भी field से, the part of product sellers, advertisements, endorsers, and even the advertisement agencies. So all this will have to be covered under the greenwashing, and the prohibitions will apply to all of them. However, the provisions will not apply to the advertisement or communication that is general and for a not a specific product or services. अगर कोई general advertisement है किसी भी services के लिए और वो specific चीज़ों को define नहीं करती है तो उस पे green washing applicable नहीं होगी. Now, substantial part of the environment claims that has been there, generic terms like clean, green, eco-friendly, cruelty-free, carbon neutral. These are the mostly term that is used by the companies, agencies in their product. Now, this has to be taken with the due care. और अगर qualify नहीं की गई तो इसको environmental claims में they are not able to use this. Now, the technical term should be explained in the consumer-friendly languages which clarify the meaning and implications, because many people are not actually aware of what is carbon neutral. You as an aspirant of civil services must be aware, but for a general public they are not aware. So everything need to be defined in a clear manner, in a layman term, so that it is understandable to and comprehend for the general public as well. Now कुछ disclosures की बात की गई है. The environmental claims must be accurate, disclosing all the relevant information. जो research data है वो selectively chosen किए जाने चाहिए. Products, processes, packaging has to be taken into consideration. Specific claims जो होंगी carbon neutrality को लेकर के, non toxicity को लेकर के, that has to be there with the certification and scientific evidence. So this all are the mandate which is there, and this will have to be taken into consideration. Regarding the claim for future, any additional or futuristic environment claim may not be made within clear actions or the plan disclosed, and this has to be, this plan must be detailed with the objective that has to be achieved. जिस कंपनी ने भी इस तरह के क्लेम्स किए हैं, क्या ऑब्जेक्टिव है, क्या पर्पस है, और किस पर्टिकुलर टारगेट ऑडियंस को वो केटर कर रही है. Now moving ahead, amendment to the FDI policy for the space sector. We'll see the detail and the part of the advancements which has been there by the government of India. So the Union Cabinet has actually approved the amendment, that is the foreign direct investment for the space sector. जो existing policies है उसमें 100% FDI allow की गई है for the establishment and operations for the satellite under the government approval route, right? Now amendment policy के मुताबिक, the amendment policies, there is up to 74% of the FDI which is allowed for the satellite manufacturing, satellite data products, ground segment and user segment under the automatic route. Now FDI beyond 74% will be subject to the government approval. Now this is very important point for prelims examination. There can be twist and turn in the statement, but you have to be aware with the precise detail. Now up to 49% under the automatic route will be allowed for the launch of the vehicles and sport craft. Beyond it, it will be subject to the government approval. See, when there is automatic route, the part of the investment can be made, but there's certain capping after which the government of India or the concerned authority has to approve it. 100% FDI in automatic route has been there allowed for manufacturing of the component, system and subsystem of the satellites. Now focus on Indian space policies 2023. This is again the vision of government of India for 2030 as well. The transitions for the ISRO role has to be concentrated on the research and development. खास के अगर बात करें research and development की, rather than manufacturing and operational space system. जो private partnership है, अगर PPP की बात करें, उसको बढ़ावा देने की कोशिश की जाएगी through the space communication services, the space transportation system and commercial recovery of the space resources. Enabling in-space. To promote in-space is actually a commercial arm of ISRO, which is authorizing for the space activities and the part of autonomy which is there with the NSIL to commercialize the part of space technologies and their platform. So what is the actual visions of the government of India under the space policy? So if you look at the strategy and vision for the space 2032, authorizing the public space activities, private investment should be there. Promoting individual international outreach, this is the second important component. The third part, that is the strategizing the Indian space sector, right? Now this has again been important considering the fact that ISRO and other important agencies like private player has made a substantial contribution. Nurturing the facilities to startup to have access to investors and creating a conducive ecosystem for private entities. Now moving ahead with other important news, that is Jammu and Kashmir Local Bodies Law Amendment Bill 2024. So Jammu Kashmir Local Bodies Law, which was passed by the Parliament, and the bill has actually looked into the three important components where the local bodies of the UT and Jammu Kashmir will be taken into consideration in the three, that is Jammu and Kashmir Panchayati Raj Act of 1989, J&K Municipality Act of 2000 and the Jammu and Kashmir Municipal Corporation Act of 2000. So these three will be taken into consideration subject to certain amendment that has been made. Now reservations दी गई है OBCs को, that is the other backward classes under the act. जो certain institutions हैं जम्मू एंड कश्मीर में रिजर्वेशन जहाँ पे SC और ST को दी जा रही थी, उनके अलावे OBCs को भी इंक्लूड की गई हैं. This institutions include पंचायत, municipality, municipal corporations, block development councils and the district development councils. The reservations are actually proportional to the populations of this group नो एक्चुअली जो पॉपुलेशंस होती है पॉपुलेशंस रेशियो के हिसाब से जो रिजर्वेशंस हैं वो डिफाइन की जाएंगी. 1/3 ऑफ द सीट्स were reserved for specifically for women. This is again an important point to be noted. Specifically for जनरल स्टडीज पेपर 1 जहाँ पे वुमेन एम्पावरमेंट की बात की जाती है, आप वहाँ पे ये पॉइंट नोट कर सकते हैं. The bill extend reservations to OBCs as well, and the group notified as well as underprivileged by the government of India under the territory of Jammu and Kashmir. Now, mandate of the election commissions. Now, this is something which you should take care of. Currently, the Jammu and Kashmir Panchayati Raj Act, the state part of the state commissions in J&K prepare the electoral roll, conduct the part of elections, चाहे वो पंचायत की elections हो, block development council की elections हो, या फिर DDC की elections हो, that is district development council. ये जो रिस्पॉन्सिबिलिटी है वो डिस्चार्ज की जाती थी बाय द चीफ इलेक्टोरल ऑफिसर्स इन द पार्ट ऑफ द केस ऑफ म्यूनसिपैलिटी और म्यूनसिपल कॉर्पोरेशंस में. तो म्यूनसिपल कॉर्पोरेशंस में और जो खास करके जो म्यूनसिपैलिटीज है उसमें सीईओ चीफ इलेक्शन ऑफिसर्स इन सारी चीज़ों को एग्जीक्यूट करते थे. नाउ इस बिल के थ्रू इट डेजिग्नेट द रिस्पॉन्सिबिलिटी ऑफ दिस इंस्टीट्यूशंस टू द पार्ट ऑफ इलेक्शन कमीशन ऑफ इंडिया, द स्टेट इलेक्शन कमीशंस. नाउ रिमूवल ऑफ द स्टेट इलेक्शन कमिश्नर्स की बात की गई है, जहाँ पे अगर स्टेट इलेक्शन कमिश्नर्स की बात करें कैन बी रिमूव through only with the order part with the lieutenant governor. So the whole sole power has been given to the governor. The ground of dismissal is there on the behavior, incapacity proved, or even inquiry or sitting by the retired high court judges of the concerned court. The bill amend that the provided that the election commission, the commissioners can be removed on the same manner as on the same ground of the high court judges. Now this is again important. Prelims में कई बार पॉलिटी के सेक्शन से आप इस तरह के सवाल एक्सपेक्ट कर सकते हैं. Now moving ahead with the other important bill, that is the water prevention and control of the part of the pollutions which is there, Amendment Bill 2024. Now this is pretty relevant for prelims because in the environment sections there can be a direct question asking you with the details of the prevention and the control of pollutions. Now the bill was passed under this particular head. It amends the Water Pollutions and Control Pollutions Act of 1974. The prevention and the control of the pollutions will be taken into consideration under the bill. The act established that the center and the state pollutions board to prevent and control the water pollution. See, we have seen the marine part where government is actually taken into consideration the water pollutions which is there, even the air pollution. These are the three important parts where this thing has to be taken into consideration. And this particular specific bill is actually focusing on the part of water prevention and control of pollutions. The bill decriminalizes certain violations instead of imposing the penalties. It will actually apply to Himachal Pradesh, Rajasthan and other union territories. This is a point to be noted. And other states may pass resolutions with applicability to the other states as well. कंसेंट ऑन द एग्जाम्पशंस ऑफ स्टैब्लिशिंग द इंडस्ट्रीज, इसके लिए मैंडेट होगी, प्रायर कंसेंट लेनी होगी स्टेट पोल्यूशन कंट्रोल बोर्ड से, जो कि एक्चुअली सारी चीज़ों को चेक करेगी. फर्दर आफ्टर इन्वेस्टिगेटिंग अबाउट द डिस्चार्ज ऑफ द सीवेज एंड अदर थिंग, दे विल हैव द assent to it. The bill proposes the central government in consultation with the Central Pollution Control Board can have an exemptions to the certain industrial categories, which is again thorough investigated by the Central Pollution Control Board, and an advice will be also taken from the State Pollution Control Board. Additionally, the bill allows the central government to issue guidelines on granting, refusing and cancellations of the State Pollution Control Board. So the whole sole authority, the apex body, if you look at the part of the environmental control, it is Central Pollution Control Board. Now penal provisions की अगर बात करें, the act establishes that the industry without obtaining such the part of punishable imprisonment up to 6 year and fine, ये penal provisions रखी गई हैं. And either tampering with the part of the other details which is there, the penal will be applied up to 10,000 rupees to 15 lakh rupees. So these are the penal provisions mandated under the new bill. Discharge of the pollutions matter, जो state pollutions control board होंगे वो इशू करेंगे immediate directives होंगे with regards to the part of the pollutions which is there for the water bodies. It prohibit the State Pollution Control Board to set the standard for the pollutions matters, and even exceptions like disposing of the non-polluting material to the land reclaimed. Right? The bill also have an imprisonment penal provisions ranging from 10,000 rupees to 15 lakh rupees for the violation. So penal provisions sometimes become important. You should know that what is actually the upper limit and lower limit of any penal provision that is there for the environmental and other, like I have told you about the examinations bill, तो वहाँ पे भी इस तरह की कुछ basic information आपके लिए जरूरी है. Now, this is the last topic of the discussion or the last news, that is the report on the judicial infrastructure in the Northeast. So, a standing committee on the personal and public grievances, law and justice has come up with a detailed report about the judicial infrastructure in the northeastern states. और ये since 1994 से अगर बात करें, this is 1994 से सेंटर स्पॉन्सर स्कीम इंप्लीमेंट की जा रही है for the infrastructure development in the subordinate code. The northeastern state, along with the Uttarakhand, Himachal Pradesh, bear 90% of the contribution under the scheme. So the maximum beneficiaries of the northeastern states are there from the center sponsored schemes. Now कुछ क्राइटेरिया रखी गई है रिलीज ऑफ फंड की. अगर बात करें CSS की, जो सेंटर स्पॉन्सर्ड स्कीम है, वो मैंडेट करती है यूटिलाइजेशन ऑफ 75% ऑफ द डिस्बर्स्ड फंड फॉर फर्दर इंस्टॉलमेंट दैट वाज प्रोवाइडेड. इस पर्टिकुलर बेनिफिशरीज में नॉर्थ ईस्ट में मिजोरम, नागालैंड और त्रिपुरा है, जिन्होंने नॉन कंप्लायंसेस विद द पार्ट ऑफ रिवाइज्ड नॉर्म्स हैज बीन टेकन इनटू कंसिडरेशन एंड रिसीव्ड नो फंड. एक्चुअली दे हैव रिसीव्ड नो फंड ड्यू टू नॉन कंप्लायंसेस, बट द थिंग्स विल बी टेकन इनटू कंसिडरेशन जहां पे उनको भी फंड प्रोवाइड की जाएगी. द कमिटी हैज नोटेड दैट दे हैव फेस्ड northeastern states such as geographical barriers, delays in their project proposals. So we need to further augment it, because the uniformity and the infrastructure development, which is actually a bottleneck for many high courts and lower court, has to be expedited in a manner where everything infrastructure development should be restored at the earliest. The recommendations considering the factor in the fund release criteria has to be taken into consideration with relaxing the existing norms. हाई कोर्ट फॉर नागालैंड प्रपोज की गई है. कमिटी ने कहा है दैट इट हैज नोटेड दैट त्रिपुरा, मेघालय, Manipur, which comes under the jurisdiction of the Guwahati High Court, will now have its own High Court. Now, this is pretty important for prelims examination. If you're one who hails from the northeastern region, this become important for you. However, the Nagaland remain under the Guwahati High Court under its jurisdictions. The committee has actually reported that a separate High Court for Nagaland and recommended a coordination between the Ministry of Law and Justice and Ministry of Home Affairs to address this issue. So this was all about this session. Hope you like this video. We'll meet in the next session with some of the important topic relevant for the examination. For time being, I'm signing off. Thank you so much for watching. Thank you for staying tuned.